case, Dwayne Lee Threadgill, CR18-0842. Counsel, good morning. We are proceeding in the circumstances using Teams, remote oral argument. Given that, a couple of kind of housekeeping matters before I call the case, and I understand, Ms. Wilhite, your camera is not working this morning. I'm sorry for that, but you're ready to proceed at the appropriate time, just using voice argument. Is that correct?
That is correct, Your Honor.
All right, and I will ask that when unless your counsel, make sure that cameras are off unless you're presenting argument, and then also make sure that you mute your line. Sometimes we get sort of odd feedback otherwise. But we have conferenced the case. We've reviewed the record. We'd encourage you to keep that in mind as you present oral argument. Appellant will be given 20 minutes for oral argument. Ms. Wilhite, you're more than happy to use a portion of that in rebuttal, but you need to keep track of your own time if you wish to do so. The proceedings are being recorded and they'll be posted appropriately in due course. And we have some court staff and clerks who are here virtually as well. And with that, Ms. Wilhite, are you ready to proceed?
Yes, Your Honor. I am going to set my timer for 10 minutes. I'm going to reserve 10 minutes for rebuttal.
Very well. You may proceed.
All right. Just a moment here. All right. Thank you, Your Honor. I'm Monique Wilhite. I represent Mr. Dwayne Threadgill, who is also present via Teams, Your Honor. Mr. Dwayne Threadgill was denied his constitutional right to confront and cross-examine the key ID witness against him. It was not simply a matter of allowing inadmissible hearsay to be presented to the jury. It was a denial of his fundamental and basic right to test the credibility and reliability of the ID witness by way of cross-examination. It is prejudice per se, it is structural error, and it cannot be fixed, Your Honor. It's a right that is tantamount to an impartial judge, an unbiased jury, and a public trial. So for these reasons, for this violation alone, his conviction should be vacated.
Ms. Wilhite, let me ask you to help specify a little bit the confrontation clause issue that you're referencing. There are at least two that are pressed in the briefs, and I want to make sure we're focusing on the same one you are.
All right. Well, Your Honor, I'm referencing one, the failure for him, the failure for the state to present the witness that identified his sample as, quote unquote, the known sample, and that is Mrs. Ducksworth. And she was the one that did not just do just did not put information in a machine. She actually, there were human actions that were taken that could have been meat for cross-examination, for him to test the fact that she followed the quality assurance procedures, that she did what she was supposed to do. And I guess the court, and just to be clear, is the court also talking about the presentation of Ms. Palmer, the fact that he was unable to ask her questions about what happened with the DNA sample? Are those the two issues that you're talking about now?
The purpose of my question was to better understand your confrontation clause argument, and I do now. Let me ask, Ms. Palmer did testify, was subject to cross-examination, and did perform DNA analysis. Is that fair?
No. Well, what she did was she provided the analysis comparing the quote unquote known sample to the sample that was found on the telephone, but she had nothing to do whatsoever with the analysis of the quote unquote known sample. And in my brief, I outlined the fact that the crime tech came to the police station while the three suspects were there. She took their, swabbed them while they were sitting next. Well, I basically together while one officer was calling out their names. She took that stuff, put it in a locker. It sat overnight. Then she came back and labeled them. And then Mrs. Ducksworth, the DNA analyst, she picked them up, checked them out, and then checked them back in. Miss Palmer had nothing to do with the analysis of those samples. She didn't know anything about it. Work. She was a supervisor. She simply received a piece of paper that said, these are the samples. And in fact, okay, go ahead.
No, I wanted to ask you, is it your argument that the Confrontation Clause of the United States Constitution applicable here required that all three of those individuals be called to testify?
Well, Your Honor, I think the Confrontation Clause required that Ms. Ducksworth, at a minimum, be called to testify because she was the one that that could say these are the known samples of this is a known DNA sample of Mr. Dwayne Threadgill, and he didn't have the right to cross-examine her.
And Duckworth and Palmer worked in the same lab, right?
Yes, that's what the information appears to be. Yes, Your Honor.
And what's your best case for the proposition that the Confrontation Clause required both individuals to testify?
Well, Your Honor, because Ms. Palmer knew nothing, because the fact that the DNA sample belonged to Mr. Threadgill was a fact that had to come to evidence. That it was not something that was part of her analysis as an expert. She needed that fact to make her testimony relevant. Otherwise,
let me ask a better question, and I apologize. I think I wasn't very clear. What's the, of the cases that have addressed DNA analysis in light of the Confrontation Clause, trailing back both federally and in the state several years? What's the case that you would submit most closely parallels this case?
Well, actually, in our, the cases that we have are Gomez and Ortiz. And in those cases, they can be contrasted to this case because in Gomez and in Ortiz, the witness that testified had knowledge of what the DNA technician did. They supervised it. They were able to testify to the quality assurance procedures. They were able to testify to what happened. Did they clean the hoods? Did they put on their robes? Did they wear their goggles and masks and gloves? And did they make sure the samples were not contaminated? All those things. But in this case, that didn't happen. Ms. Palmer could not testify to anything. She did not observe any portion of Duckworth's work. She had no personal knowledge as to when or where it happened, how she tested the samples, or the quality assurance protocols that were followed. She couldn't even testify. She couldn't even hearsay that information in because she didn't have any personal knowledge about it. So Gomez and Ortiz actually helped this case because nothing that happened in Gomez happened in this case. They were able to testify as to what happened with that DNA analyst. Did you have any other questions along those lines?
I have one more, but I want to make sure I'm not using your time and my colleagues' time imprudently. But in Gomez, didn't that sort of allow a similar thing that happened here, where the testifying expert formed their own opinions based on a type of data that experts in the field normally rely on? Isn't that what happened here?
But in Gomez, that testifying expert, she reviewed the work of the analyst. She could answer questions about the results. She could form her own opinion based on her personal knowledge. And in this case, the testifying witness only had a piece of paper that said, these are the known samples. And she couldn't answer any of those questions. In Gomez, the attorney could ask those questions of the witness because she did have some personal knowledge. She did oversee that work. And in this case, this witness could not.
And so Palmer was asked those questions at trial, but just was unable to answer.
Well, she was actually not asked those questions, Your Honor. She was she basically said I received it on a piece of paper and then I did my analysis to determine whether there was a match.
Does the lack of cross-examination matter to us, or should it?
In terms of what the defense attorney did, or just in general in terms of the confrontation clause?
The latter, for purposes of today's argument, yes.
Well, no, Your Honor, because even if he asked those questions, she couldn't answer them. I mean, he mainly objected to the foundation, and I think that I think that he did the right thing because he knew that she couldn't answer those questions. She admitted to the fact that she had no personal knowledge. So there was nothing that he could do. And the state should have produced a witness that could do that because the state has the burden of proof and the burden of production. And they defiantly, they just didn't do it. They didn't even give a reason as to why she couldn't be there. And so, I mean, this just falls right in that category of a wholesale violation of his constitutional rights. He didn't have an opportunity to cross-examine the key ID witness against him, Your Honor. And I believe that my time is up.
Very well. Thank you, counsel. And I have about 10 minutes and 30 seconds in rebuttal. Mr. Valenzuela.
Good afternoon, Your Honors. May it please the court. My name is Michael Valenzuela, and I represent the state of Arizona in this matter. Your Honors, the Confrontation Clause prohibits testimonial statements from witnesses that don't appear at trial unless that witness is unavailable and the defendant had a prior chance to cross-examine the witness. When the state here offered evidence that a DNA match existed between a swab taken from the cell phone and a buccal swab taken from the defendant, it made the expert who reached that opinion available for cross-examination. While Threadgill is now arguing that he should have been able to cross-examine the technician who helped process his buccal swab, the state offered no testimonial statements from that witness into evidence. For that reason, his Confrontation Clause argument fails, as well as his arguments about the joint trial, his conviction for possession of a narcotic drug, and his conviction or his consecutive sentences. Now Threadgill's argument really relies upon his assertion that Duckworth was an ID witness against him. He hammers this home in his reply brief. But Duckworth had no independent knowledge that the swab taken from Threadgill actually belonged to Threadgill. That knowledge came from Kendra Eckert, who was the person at the police department station that took the swab, assigned it an inventory number, and then labeled it as belonging to Threadgill. And the state called that witness at trial, and that witness was available for cross-examination. From that point,
counsel, let me ask you: we have Ms. Eckert, who testified, and we have Ms. Palmer who testified, right? But the links in the chain they're three, right? And Duckworth is that middle link. Help us understand why Duckworth wasn't required to testify.
Well, there's two reasons primarily that she wasn't required to testify. The first is that in a general sense, the state is not required to call everybody in the chain of custody to testify at trial in order to satisfy its confrontation, in order to satisfy the defendant's confrontation rights. The Confrontation Clause applies to any witnesses that the state presents testimonial statements from. And in this case, the state did not present any testimonial statements from Duckworth. If it had, then the state should have been required to present her for cross-examination.
Let me ask you then, and I know there's a second point that you haven't gotten to yet, and I want you to get to that. But that there is a limit on what you just said, isn't there? Because Palmer couldn't just sort of take a document that someone else had done all the work for and then come and testify, and the state then say, well, there's no confrontation issue to see here because we had one person who testified.
Yes, you're correct. There's absolutely limits, and those limits are set forth in the United States Supreme Court cases of Melendez-Diaz and Bullcoming. If you compare those cases to this case, you can see why this case is distinguishable from those types of cases. For example, in Melendez-Diaz, you had the state present an affidavit from someone who had conducted drug testing, and they entered that affidavit into evidence without calling any expert whatsoever to testify about that opinion. And the court found that, yes, of course, this is a confrontation clause violation because the state's presenting a testimonial statement through these reports and no one's been made available for cross-examination. Then in Bullcoming, you have a situation where the state calls a witness, but it's not the witness who wrote the document that was admitted into evidence. In that case, you had a certified document admitted into evidence that attested to certain blood alcohol content testing. And the court there said, well, although you made a witness available for cross-examination, this witness was merely parroting information that was contained in this certified report that was admitted into evidence, and that's not good enough. Now you contrast that with this case, and first of all, there was no report that was actually admitted into evidence. Not even Palmer's report was admitted into evidence. We have it because it was marked for appellate purposes, but the jury, that document never went back to the jury. So that fact alone makes this case quite distinguishable from those two other cases.
What if, though, and again, hypothetically, instead of admitting or offering the written document and having it being admitted, that the testifying expert effectively testifies to everything that's in the document? Does the form of how it comes in really that significant, or is it what the information is provided in testimony or evidence?
It is the form in which it comes in, because particularly if you look at our Supreme Court's decision in Gomez, they explain that an expert can testify without violating the confrontation clause about facts that they rely on in rendering their opinion. And the court in that case quickly disposed of the confrontation clause argument that that the expert in that case had violated the confrontation clause in rendering her opinion based on facts from another person. So in that regard,
how do you account for the mere conduit concept that courts have condemned, that witness A can't be a mere conduit for what witness B, who doesn't testify, actually did?
Well, that really takes into account when someone is, making some kind of a testimonial statement or assertion, like in Bullcoming. Those certified reports were saying there was a test and the test said X. And then the witness who comes into trial and testifies says there was a test and the test said X. But that person has no independent knowledge that the test actually said that. The assertion, the testimonial statement that's being made in that situation is that the test said X. And in this case, what was important and what accused Threadgill of criminality in this case was not the fact that a test was run. It was Palmer's testimony that I reviewed these charts and these graphs, and based on my own expert opinion, there is a match between this one graph taken from Threadgill and then this other taken from an item found at the crime scene. Now, if a witness had come in and merely parroted that opinion, saying there was a match between these two things, but I'm just relying on the report of another, then that would be a confrontation clause issue. But when you're just relying on other facts to reach an opinion, that's not a confrontation clause issue. And I would like to point you to our Snelling case that's cited in the briefs that's very analogous to this situation. In Snelling, you had a situation where an autopsy was performed by one medical examiner, and then a different medical examiner came into court to testify about the cause of death. And that medical examiner relied on the autopsy in rendering their opinion on cause of death, but their cause of death opinion was uniquely their own. It wasn't taken from the initial autopsy and merely parroted in his testimony. That's the thing that's happening here. She's merely taking the machine-generated graphs and charts and then using those to form her opinion. And I think it's important too that those are machine-generated graphs and charts, because this court in Ortiz explained that the machine-generated DNA profiles, just those charts and graphs, are not formalized statements, and for those reasons, they don't trigger the confrontation clause. You can also look back to the Gomez case, which really controls the situation at hand here, and in that case, the court explained, and this goes back to a point that's heavily relied on by Threadgill. There, it was a fact that the supervisor was the one that testified. But the court's holding in that case wasn't that a supervisor needs to testify. I want to read to you exactly what the court said. And this is at paragraph 20 of the Gomez opinion. It says, consistent with Pendergraph and Boyd, other jurisdictions have held that DNA profiles may be admitted at trial when the laboratory technicians who handled the samples and obtained the machine-generated data do not testify, as long as someone familiar with the profiles and laboratory procedures is subject to cross-examination. It's that familiarity with the laboratory procedures, which is the test. And in this case, that test was met because Palmer worked in the same medical lab as Duckworth. She was able to testify about the procedures that lab uses in rendering both unknown profiles and profiles taken from a source that's known. She was able to explain that the lab is accredited, that the lab is subject to audits, and all of those things supported the trial court's ultimate decision that she had provided sufficient foundation and assurances of reliability to testify as to those facts.
Is it the state's position that the failure to call as a trial witness a person in the position of Duckworth's position, it might be Duckworth, might be a colleague, might be somebody completely unrelated, that would never create a confrontation clause issue?
Absolutely not. There would be a confrontation clause issue if the state presented testimonial statements or testimonial hearsay from that person. So if the state, for example, had admitted into evidence a certified report from Duckworth, then there would be a confrontation right to cross-examine Duckworth. The difference is with this case, there was no statements from Duckworth admitted into evidence, not even if we want to stretch the limits of testimonial statements and say that if Palmer had relied on a testimonial report in rendering her opinion, then there could be a confrontation right to cross-examine Duckworth. But if you look at the exhibit that was marked for appellate purposes, Palmer includes the documents that she relied upon in reaching her opinion, and none of the documents in the appendix to her report show the type of formalized statement, any kind of really formalized document from Duckworth whatsoever, let alone the type of a formalized document that would trigger the confrontation clause. And it's important to note that the confrontation clause, it doesn't apply to all statements, and it doesn't require reliability of all statements. It applies to a very narrow segment of statements. If you look at Justice Thomas's concurrence in Williams, he explains that the confrontation clause applies to a specific class of testimonial statements, those formalized statements bearing an indicia of solemnity. Now, I know his theory on the indicia of solemnity applies to him and him alone, but if you look at Justice Thomas's concurrence in Williams, and you look at the primary purpose test that's relied on by the plurality, both of those tests, you have 5 judges incorporating a requirement of some type of formality in a statement for it to be triggering the confrontation clause. And that's not too far out from what our own courts have required, that there be some type of formality in a statement to trigger the confrontation clause.
Counsel, you're not arguing, are you, that Duckworth's report was just sort of slapped together? I mean, that's a formal document that was intended. Duckworth knew exactly what it was going to be used for. I mean, the thought that whatever Duckworth did might not either be or approach testimonial it seems sort of curious to me. Now, that's a different issue than whether Duckworth needed to testify. I concede that quickly. But is your position that Duckworth's report was not testimonial under the confrontation clause?
Well, we don't know. We don't know what Duckworth's report is because we never saw it. It was never marked as an exhibit. It was not part of Palmer's report that was marked as an exhibit for appellate purposes. And so, I mean, we can only really speculate as to what the form of it was and whether it was formal or not. But the confrontation clause, it applies to things like affidavits, depositions, certified or statements of fact that are certified, or statements that are the result of a formalized dialogue like custodial interrogation. And so,
or a 9/11 call, depending on the context, right?
Sure.
I mean, I don't know that we have to decide that, but I thought I hear you saying something different about what Duckworth's report either was or could have been.
Right. Without seeing the report, it's hard to say whether if it had been admitted that it would be some type of, whether it would be formal or not. But I realize that there are concerns about when the state uses this type of evidence and the person who runs the test hasn't been called and hasn't been cross-examined. And Threadgill expresses many concerns about the fact that he wasn't able to cross-examine a witness about the reliability of Duckworth's work and whether there was any kind of cross-contamination in that work or not. And those are concerns that he can readily address in his trial. They're just not concerns that are addressed through the confrontation clause. Those are concerns that are addressed through the weight of the evidence and the sufficiency of the evidence and foundation. And by the state not calling Duckworth to testify at trial, it gave Threadgill the opportunity to argue to the jury, hey, look it, the state didn't call this person at trial, that it was a link between the testimony of Eckert and the testimony of Palmer. And so we have no idea what happened at that stage. And she could have contaminated it. She could have mislabeled it. There could have been all kinds of things that happened. And for that reason, the state hasn't met its burden of proving identity beyond a reasonable doubt. And for that reason, the state hasn't proved in its entire case beyond the reasonable doubt. And without that link in the chain, you just can't find my client guilty in this case beyond a reasonable doubt. And the jury could have sat and listened and said, you know what, he's right. The state really should have presented that evidence. And we don't think that the state's proved its case beyond a reasonable doubt. And that's the remedy that's available to the defendant, is making that argument and hammering home that missing witness to the jury. But it's not a confrontation clause issue. The confrontation clause applies to these narrow statements on testimonial statements or testimonial hearsay, and says that when those types of statements are admitted at trial, then there's a right to cross-examination. And here, there's not a statement. If anything, there is an informal implication from Duckworth somewhere in Palmer's testimony. But informal implications are not the types of things that are subject to the confrontation clause. If the court has no further questions on the confrontation clause issue, the state will rest on its briefing on the remaining 3 issues.
We look to my colleagues. Any questions for the state? All right. Thank you, counsel.
Thank you.
And then for rebuttal, Ms. Wilhite, I do have you at about 10 minutes and 30 seconds.
Thank you, Your Honor. First of all, I think that it's clearly testimony. It's basic. It's hearsay. It's an out-of-court statement offered for the truth of the matter. And the truth of the matter, Your Honor, is that she testified that the fact that the profile belonged to Dwayne Threadgill. On the August 7th transcript, page 70, line 21 through 22, were you given a known profile for Dwayne Threadgill? And she testified yes. She also testified on page 71. So Carol Duckworth generated these known profiles for Darqueen Wilson and Dwayne Threadgill. Is that correct? Yes. And so you compared your DNA profiles. I'm sorry, I don't know what happened. So you compared your DNA profiles generated with Darqueen Wilson and Dwayne Threadgill's known DNA profiles. Yes. So she testified to a fact. And in this case, Miss Duckworth did not prepare a report. And she simply, I don't even know how she came to her conclusion. We just have in that exhibit 253 The only thing I could find with any clue was the assignment notification report, which actually asked Ms. Palmer to analyze the DNA to connect the two or the suspects to the case. So I don't even, we don't even have a checklist. I don't have a checklist that I saw Ms. Duckworth complete or anything like that. We just have Ms. Palmer testifying to the fact that these were known DNA samples from Mr. Threadgill. That is hearsay, and that is a fact that Palmer needed to have in order to present that ID issue. I mean, the state needed to have to present that ID issue to the jury. And it's not cured by making an argument about why didn't they bring this witness. This is a constitutional right that's embedded in the Constitution. It is the chosen way that you are to determine the credibility and reliability of evidence. It's as if saying, oh, okay, well, he didn't get an initial appearance, but he's guilty anyway. He doesn't get one. He doesn't get an arraignment, but he's guilty anyway. We can fix it later. You can't fix this, Your Honor. You have to send it back. He had the right to cross-examine the person that said, this is your DNA profile. And in Gomez, there was no certified report, but the court assumed, okay, we're going to just assume for purposes of deciding this case that, this is a testimonial statement, even though it wasn't a report. This was a fact. And it was a fact that the state needed to prove its case. Otherwise, Palmer could just say, I looked at some DNA profiles, I matched them to the DNA profiles at the scene, and there was a match. But who did it match? So it wasn't just a matter of some casual information made to, by the way, this is Threadgill's DNA. This was a crucial fact that identified Mr. Threadgill. And in Bullcoming, in that particular case, the person who did the blood sample analysis was not available, but he did things to analyze the blood sample. And in this case, Duckworth had the knowledge about picking up the samples from the lab, when she tested them, how she tested them. Did she test them at the same time? Did she follow all the protocols? How did she know she followed all the protocols? Did she wear a lab coat? All those things. That was not even presented through Palmer. She couldn't even talk about that information. So the only thing she could talk about was her comparison. But she needed to have the fact that the known sample belonged to Threadgill in evidence for her testimony to be meaningful. So she was a surrogate for the fact that the DNA sample belonged to Threadgill. So she was a conduit for that information. That fact needed to be proved, and it needed to be proved with a witness, and a witness who could testify. She didn't just take information and put it on a machine. She went through protocols and procedures, human actions to do that. That is, as Justice Ginsburg would say, meat for cross-examination. So it's not about, and it can't be cured by determining whether or not, there was harmless error, and would the jury have found something different if there was cross-examination? No, this is a process. It's not just about would he have been found guilty. This is his right to confront and cross-examine that witness, just like his right to an arraignment, just like his right to an initial appearance, just like his right to a fair trial, an impartial judge, and an unbiased jury. All of those rights are part of the structure of the trial process that the framers put in place to make it fair. And so you can't just fix it by saying he can argue, reasonable doubt or probable, you can't just fix it like that. He has to get that right. Mr. Threadgill, the Constitution applies to him too. He gets the right to confront and cross-examine the witnesses that testify against him. Your Honor, and as far as Williams is concerned, and you hit on this, they prepared that Williams case, it's a plurality Supreme Court case, but as you noted, this was prepared for the purpose of accusing and targeting Mr. Threadgill. It was created in anticipation of the trial. And the people who analyzed it knew the consequences. And in Williams, there was really no possibility of contamination. It was done by a third party. But that's not the case here. There was a possibility of contamination. And in Gomez, that testifier or that witness reviewed the work of the analysts, and they could answer those questions, and they could say that the quality assurance measures were followed. Miss Palmer couldn't do that. He couldn't even cross-examine Miss Palmer. So not only was Miss Duckworth not there, but Miss Palmer didn't even have the information. So, and then when the issue came up, the state didn't even say, well, he didn't make a showing that she was unavailable. Well, we know that there was no previous opportunity for cross-examination, but it just falls square in the confrontation, the type of actions that the confrontation clause was designed to protect from. And as far as Ortiz, once again, that testifier, that person who testified, reviewed the work conducted by others, and they could ensure that the procedures were followed. And that's not the case here. So this court can vacate these convictions without doing any harm to Gomez or Ortiz, or and totally follow the Supreme Court in Bullcoming, Melendez, and Crawford, Your Honor. So this is structural error. No substitute procedure can cure this violation, and no showing of prejudice is required to make this violation complete, Your Honor. Mr. Threadgill had the right to confront and cross-examine Ms. Duckworth and also Ms. Palmer. She couldn't do that because she didn't have the information. And he was denied a fair trial, and his constitutional rights were violated. And as I said in my brief, no, it can't be harmless. And as with respect to the other issues in my case, I stand on the brief, Your Honor, on our briefs. And unless the court has any questions, I'll end in just a few minutes. But before I lose my time, I want to make sure that the court doesn't have any further questions.
I look to my colleagues. Any questions? No. Please continue, counsel.
Okay. So Your Honor, and I think that this whole case hinges upon this issue. And as far as the abuse of discretion in the other issue with respect to the rub-off effect, I just want to emphasize that the Superior Court judge said we're going to sever these cases, but the trial court, in essence, let all the information in that would prejudice Mr. Threadgill, and thus there was a rub-off effect that affected his ability to have a fair trial. And the abuse of discretion lies in that trial court simply really just not doing what the motions judge said that he wanted to do, how he ruled. He ruled that the case should be severed. And although the formal charges were not presented to the jury, the facts of the charges were. So in essence, he was prejudiced. And along with the other issues with respect to the insufficient evidence, and I stand on the brief, Your Honor, and also on the sentencing, I stand on the brief. And just emphasize with respect to issue 1 that this is prejudice per se. It is structural error. It cannot be fixed, Your Honor. And we ask the court to vacate these convictions.
Counsel, thank you. We appreciate your briefing. We appreciate your oral argument today. We will take the matter under advisement, and we will issue a written ruling in due course. Court is adjourned. You're free to leave at this time. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.